first case this morning is Azar versus County Fiscal Office. Each party will have 15 minutes to present their arguments. In this case, Mr. Morgan, obviously you have no one to rebut, so you have your 15-minute time altogether. Okay. Either you know the arguments are being recorded. When you present your argument, please make sure you introduce yourself. Please stay behind this podium so that the video and the recording can pick you up well if you would do that. I don't think it applies in this case, but if we had a victim or child or anything to name used by initials, but again, I think in this case we don't have any of those folks to worry about. We read your brief, are ready to proceed whenever you are.
Alex Morton on behalf of the appellant Fred Azar. So the reason we're here is Mr. Azar's property value went from $31,000 to $263,000 in 1 year between 2019 and 2020. This was the work of the fiscal officer, Summit County fiscal officer. I think on its face to anyone, that makes no sense. Properties do not go from $30,000 to $263,000 in 1 year. If you were to say that to any of the taxpayers in Summit County, they would laugh in your face. So I don't know, having read the briefs, hopefully you did, I don't know whether any of you could offer an explanation for that, how that could happen. But I think we would all like to know, how could that happen? Well, we did eventually find out the answer. The answer of the fiscal officer was, well, we gave a discount back in 2012 and we took it away. And that discount was given because the certain lots were combined into one lot. Okay. Well, property tax value, the fiscal officer's job is to determine the market value of the property. True value in money, a constitutional term found in Article 12, Section 2 of our Constitution. True value in money means the truth. I think that term came back in the first half of the 19th century. That term originates from back then, 1850. All right, so and it's been further defined as market value. It's right in the statute. So the fiscal officer's job is to determine market value. The fiscal officer can't give or take away discounts because that has nothing to do with what a buyer will pay for it. So this reflects, actually it reflects a complete disregard for the law by the fiscal officer.
Well, I read the deposition of the gentleman for the fiscal officer who testified. I understand that deposition, him to be saying, we took some properties that were sold in 17 and 19, although all these properties had homes on them, and we attempted to do some comparative values of the land on that property. They didn't just say, we just pulled this out of the air and have no idea why. They said, here's what we were trying to do. We were attempting to look at the property that had been sold. And we're trying to extrapolate from that what this value of land was in this particular area. Do you not read that, how their deposition?
Yeah, I did not read that in the deposition. Okay. Basically, they gave a discount and took away a discount based on the lots being combined.
Right. Certainly, they do acknowledge that. In 12, they claim there's some system in which when lots are combined before there's a new appraisal, they just keep it all at the same value somehow.
Yeah, but
and then in 14, oops, we forgot to redo it, and so now we're redoing it in 20. What right. They seem to be telling me, which.
Right, but I mean, do you understand what I'm saying? Is it's market value.
They do. How are they supposed to find market value other than looking at other properties that are sold in there?
Well, first of all, that's not how they found market value, right? They just gave and took away discount.
Well,
I mean, you're reading
we
into
will go
this.
back and read the deposition as to what they said.
I know that deposition very well. I'm not drawing out of it anything that you're saying.
Okay.
So if you can point to that in your decision, it would be appreciated. Okay? It's market value, and that has nothing to do with market
Are
value.
they required, the only testimony your client presented was his own view of what the value's worth? And certainly, our case law said that's competent evidence. He can testify the value of the property. Are the folks at the Board of Revision, the Board of Tax Appeal required to accept his testimony as to that?
Right, the owner's opinion is always competent evidence. That's true if you had a piece of jewelry or whatever. You could say, this watch is worth $30,000, and the guy says, well, I'll pay you $3,000. That's what it's worth $3,000, what he'll pay for it. But the owner's opinion is competent evidence. So then we go to a prima facie case, right? The owner has pleaded $40,000. He's attempted to prove $40,000 by offering his opinion, which was substantiated by related facts he testified to at the Board of Revision hearing. Okay? So that's the prima facie case.
If the Board of Tax Appeal find that not to be credible.
They can't find it not to be
So
credible.
your view is the law requires them to find his testimony credible.
There's no question about it. It isn't my view, that's the law. Credibility and weight are not at issue in a prima facie case. Credibility and weight are not at
In
issue.
what case would you be citing?
State v. Tompkins, if you look at State v. Tompkins,
What about from this area of the law?
that's the Ohio Supreme Court.
Well, that's a criminal case, but what about this area of
It
law?
makes no difference in a civil case. It's the same standard.
Yes, but I think what Judge Stevenson is saying, though, is that's just the general standard about weight of the evidence. But what we're saying is, when you have a presumption, okay, and what you're arguing, I think, is that there's the presumption from the fiscal officer, right?
No, I'm sorry, there's no, you're saying we have a presumption of what?
Well, I'm not sure what you're saying. I'm sorry.
You're
I
not sure what I'm saying? Okay, here,
But-
I can explain to you very simply what I'm saying. The burden of proof is always on the person who wants to change the status quo. That's
Was
called.
it your client in this case?
That's
Pardon me?
what, yes.
That's your client in this case. There's been an appraisal of whatever.
Correct, the appraisal
Your
was-
client wants it to be different. So
Yeah.
your client has the burden, at
Burden.
the Board of Revision and the burden at the Board of Tax Appeal to present evidence that says it's different.
So do you understand the burden of proof? I mean, there's in the.
Why don't you educate me?
Pardon me?
Why don't you educate me about the burden of proof?
It's a preponderance of the evidence, right? This is a civil case. It's a preponderance of the evidence. It's the weight of the evidence. Who has the greater weight?
In calculating or deciding weight, doesn't the person making the decision have to figure out if someone is or is not credible?
Well, the issue is this. Property owner makes a prima facie case by stating his opinion. Then the burden of coming forward with evidence shifts to the opposition.
So if I go to the Board of Revision and say my property's worth $1,
No, that's
then they
not.
have to accept. I made a prima facie case. I testified.
No, you didn't, because the standard is it reasonably could be.
Well, who
That's-
decides reasonably could? And if the
Well, I
Board of Tax
think-
Appeal decide 40,000 isn't reasonably
Wait,
could.
who decides reasonably? I mean, I think it's a matter of common sense, okay? In other words, if you ask any voter in your district, okay, how can if a property was worth $40,000 by the fiscal officer's own determination in 2019, how could it be
Is the
260?
standard in this case a reasonable voter?
No, I mean, in other words, if you want to do it that way, then ultimately,
Well,
I guess,
again, what is this? We have a standard review in this case. What's our standard of review?
de novo, this case presents strictly legal issues. We have an adjudication problem here. The Board of Tax Appeals does not know how to adjudicate a case. These are cases in law cases. They don't know how to adjudicate a case. They don't know what a prima facie case is. They don't know what a sufficient case is. I've cited you all the case law you need. It's State versus Tompkins. That's a landmark case. And if you want to read Justice Cook's concurring opinion, she says the facts are assumed to be true. I mean, that's just basic law. Weight and credibility are not at issue in a prima facie case. Prima facie is a Latin term. So this goes back to the Roman era. Okay? So,
Council, I have a question about the Board of Tax Appeals order. And I understand what your argument is, but bear with me because I have a little bit of confusion about how we ended up with this value when there was a slight change at the Board of Tax Appeals. It says that the record shows that the fiscal officer considered the size, character, and location of the land at issue, which utilizes the computer-assisted mass appraisal to value the subject property. So focusing on character, obviously size is right there, and location is right there on everything, but character.
Well, wait.
Let me finish my question, please. Character. Whether you agree or not, there is evidence in the record as to the character of the property. When we get to the bottom of the judgment entry, or I'm sorry, their decision, it says, it is without question that an additional acre of land valued at $33,000 was improperly included into the initial value. Accordingly, we find it appropriate to reduce the initial value by that amount and the land and the value of the land at $660. I'm trying to understand is that $33,000 parcel that they said is not a part of this.
yeah.
Did that affect the $6,600 valuation of the rest of the land?
Well, I
Can you
think,
just excise that out?
okay, well, let me put it this way. I think it would be nice if you had someone here from the fiscal office to explain it, okay? I can explain it to you if you want, but I don't really want to use my time doing that. I've made it very clear to everyone here. Owner's opinion, accepted as true, burden shifts to the fiscal officer. Fiscal officer has to come forward and explain what this was all about. They explained it. We gave a discount in 2012 and took it away. That's nonsensical. And the prosecutor represents the fiscal officer, so the prosecutor doesn't know what's going on with respect to property tax law. Okay? What you're talking about is a minute point that has nothing to do with the essence of this case. They calculated the acreage where they thought they said they thought it was a house. They thought there was a house on it, so they gave it a per acreage rate higher than it should have been. There was no house, so they took it away. That's what dropped it from 296 to 263. That's minutiae, okay? I'm saying this
But
to you.
it's all combined into one lot.
Pardon me?
At the time they're doing the reappraisal, it's all combined into one lot, correct?
In 2020.
No, it was actually combined into one lot in 2012.
Right.
And they gave a discount then, and then took it away, but that is absurd. The fiscal officer can't give discounts. The fiscal officer's only job is to find the true value in money, which is defined as what someone will pay for it. Fiscal officer can't discount what someone's going to pay for it. Let me conclude by saying this. You folks could do two things that would be a great service to your voting public, the taxpayer, people that pay everyone's salaries here. You can find that the Board of Revision has an obligation upon request of the property owner to bring a fiscal officer into the BOR hearing, the Board of Revision hearing, so that the property owner can cross-examine that person saying, how did you come up with my value? And point two is you can recognize that the owner's opinion is competent evidence and that it establishes a prima facie case and shifts the burden of proof over to the burden of producing evidence over to the fiscal officer. They've got to defend the case. They've got to come in. Any other decision is just going to be seen as deep state politics. That's what is going on here with the BTA. Deep state politics. And I think that's about all I have to say.
Seeing no further questions, thank you for your presentation, Mr.
Okay.
Morton. The court will take the matter under advisement and issue a decision in due course.
Okay,
The clerk of court will mail a copy of the decision to you in the date released.
Right.
And also will be available on the I-16 court website. Thank you.